I guess the format of this, Lane kind of asked specifically about Minnesota laws, and I will touch on that briefly at the end. I'm not an expert in Minnesota law by any means, and I kind of have been cobbling this information together as it's been presented to me by different people in different capacities. So if I have anything about Minnesota wrong, or if anyone knows anything that I haven't brought up, please feel free to add that, because it'll help me learn, help your fellow participants. So I'll just generally go through right to burn acts, the statutory reform surrounding prescribed fire in the United States, how they came about, what they look like, how they come about individually in a state, and then some resources for thinking about who one might reach out to if they have needs or questions surrounding prescribed fire legislation or any other component of prescribed fire. And then I'll touch on the Minnesota laws briefly, and hopefully we can open that up for a broader chat with the group. So the rise of a right to burn was essentially in Florida. In 1990, there was this case that came up, Midyett versus Madison. It reached the Florida Supreme Court, so it was a pretty big deal. This was a Forest Service burn that jumped a boundary and burned up some trees. And the court basically ruled that setting fire wasn't inherently dangerous. So that kind of speaks to this very overarching danger to this thing that people were doing, and it was pretty prevalent across the state, prescribed burning, even back in the 90s. And so that concerned a lot of people, that the court was finding this broad dangerous propensity to prescribe fire, and they were concerned that a lot more court cases would come out this way if there were additional escapes. And so they said that it was self-evident that smoke blowing across a heavily trafficked area possesses a dangerous propensity. And so the people that were doing the prescribed burning got together and created prescribed burn councils that we know so well today. It didn't quite have the same format that we see today. That's pretty structured across states. And they pushed for this statute 590-026, which has changed over time. And this was the Florida Prescribed Burning Act. And so it became law for the promotion of prescribed fire, and explicitly stated that prescribed fire is this land management tool that benefits Florida. And then modifications occurred in 1999. We'll go over that a little bit later down the road when I go through this roadmap about what these right to burn acts look. But this was basically the first right to burn act in 1990. So what do these things look like? So the right to burn acts, or prescribed fire acts, they go by a lot of different names. Basically, they codify the right of a landowner to burn. And that's really important. And a lot of people they jump right away to some of the details like the CPBM programs or liability standards, but this making it a right of a landowner to burn, that's the big component of these things that really stands out to me as an important piece. So they also establish a liability standard that will be applied in the case of escaped prescribed fires or injuries from or damages from smoke drifting across roadways, that sort of thing. They place the burden of the proof on the plaintiff to prove burner negligence, and this becomes important. I'll show an example of why that is. They establish certified prescribed burn manager programs. They incentivize certification in those programs, and then they establish the other regulatory requirements that will be attendant to prescribed burning in the state. Now, not every state has all of these components in their right to burn acts. Some of them are very bare bones and will only have a few components, but these are all the different pieces of the puzzle that can be included. And I'll go through them so that everyone here has an idea of what the range of possibilities for these different statutes look like. So codifying the right of the landowner to burn is pretty important. A lot of states prior to having a right to burn act will have criminal negligence for escaped fires. The codification of the right to burn takes that away for the most part. It removes that nuisance cause that you can file against someone for burning, and leaves only civil liability as the recourse for an escaped prescribed fire. And so this is what the original Florida regulation looks like. It's clearly states that prescribed burning is a land management tool that benefits the public, and it can be more or less explicit about that. And it shows this legislative intent. That's an important key piece of this. The legislator created this law because they thought it was important to the public. And so prescribed burning gets promoted by these rules via this legislative intent. And so that becomes really important. And I'll talk a little bit about how these laws get created, but sometimes they're piecemeal, where the state will just establish this legislative intent, and they won't get the liability standard that they want, and the whoever's promoting the legislation. But later down the road, there's an opening for that to occur. And the reason is because the legislature has created this right to burn and shown this legislative intent. It also comes into play in court cases, and I'll show you an example of that. So prescribed burning is essential to the perpetuation, restoration, and management of many plant and animal communities, and talks about the loss of biodiversity. Georgia's act goes on to say that the reason that they have created this statute is because of pressures from liability issues and smoke nuisance complaints and limiting prescribed burning. And so they specifically state that the purpose of this act is to promote prescribed burning. And so that creates this large support from the legislation to prescribed burning in the state that plays a big role in court cases when they come up. And so this is just kind of an example of that legislative intent that I mentioned. This was also a case from Florida. Florida and Georgia have a lot of the cases that went up to the Supreme Court, which is where they are more searchable than just in a district court, where you have to know at least someone who was involved and the date on which it happened and which district it occurred in. So a lot of the examples that give you are from the Supreme Court, and Georgia and Florida have the largest amount of those. And so this was a case where there was a burner that was doing a prescribed burn. The burn was wrapped up, and then the next day smoke was laying down across the road, and there was an accident related to that smoke, but it was after the burn had been wrapped up, and there was smoldering that was going on, and the subsequent atmospheric conditions were what the court picked up on. And so this was at the appellate level an overturning of the jury verdict, which said that this Florida burner was liable. And at the point in time when this case came up, there was gross negligence, and I'll talk about what that is. That's the liability standard. And so the court basically said that because of the legislative intent of this act, where we are trying to promote prescribed fire, then thinking about the subsequent atmospheric conditions and how they contributed to this accident, you could not possibly conclude that someone was grossly negligent. So this high liability standard. And so they go on to say that interpreting it as the jury did would thwart the legislative purpose of the certified prescribed burn statute. So that's how that legislative intent really comes into play. So that leads us into establishing liability standard. I mentioned gross negligence. In a lot of the research that we've done some social science looking at what are the barriers to burning for people, and consistently personal liability or risk comes up as one of the number one reasons why people don't burn. We see that in different parts of the country. We see that in different components of burners, from agency to private lands people. And so keep that in mind through this. This is why people are really focused on this legal liability when they're talking about right to burn acts. Also, we see burn bans inhibiting burning a lot, and that'll come into play when we talk about certification. So there are these three different liability standards. This map I try to keep pretty up to date, but it's, as I said, as information comes in, I update it. I just found out yesterday, I think, that South Carolina now has or will soon have gross negligence for prescribed fire escapes as well as smoke. So that's out of date already. And one thing that we're trying to do is find a way to keep all this information stored somewhere and up to date. And I'll talk a little bit about where we're thinking we might do that down the road here. So there's strict liability where a burner is liable for any damage caused by an escape prescribed fire, regardless of their action. And that is that, if you think of that language from Moyet, the Florida case, where they say it's an inherently dangerous act, that's kind of where this strict liability comes into play. So Minnesota had been defined as strict liability mostly because of court cases and district court cases that came up and how the courts were interpreting it, and the fact that there is no clarifying statute that says this will not be applied. However, that's kind of a wishy-washy statement to say that it's strict liability. It's not statutorily defined. That's just what's indicated by how some of the court cases have come out. And I'll talk a little bit more about that when we talk specifically about Minnesota. And then there's simple negligence. This requires a burner to practice reasonable care in applying their prescribed fire. This is the most common standard applied, and this is the standard that's applied in most of those states where you see undefined as your category. That just means there is no statute that defines what the standard will be, but simple negligence is typically what a court will apply in that case, because that's what they apply to all personal injury and property damage cases. And then gross negligence is kind of this Cadillac of liability standards that really limits liability for prescribed burners. And it requires a burner to follow a codified set of regulations regarding burning in most places to obtain this level of liability limitation. And in order for a plaintiff to recover under a gross negligence standard, they must show that the burner had reckless disregard of the duty of care owed to others. And so this is a very high standard of liability, and the plaintiff has to prove that there was this wanton or reckless behavior going on in order for them to recover in a case of escape prescribed fire. So if we look back at that Midyat versus Madison, that we see that strict liability language there. It's inherently dangerous. And then this modification, or this prescribed burning act came to be. And then they really realized liability was limiting to folks burning. And so they did this modification in 99. It added the certified prescribed burn program and lowered liability for certified prescribed burn managers, and those that were also following the regulatory requirements, of which Florida has a few. And so really the kind of importance of this for a lot of places is that it does incentivize these liabilities or these certification programs. And I'll talk of this more in the certification section, but if you have a statute that creates the certification program, but there's no teeth to making or requiring someone to be certified, then why would they bother to go out and get the training? And so there's a few components of ways that people can be incentivized, and I'll talk through those a little bit. And then the second thing, it's a burden of liability away from a burner, not to say that they aren't liable and shouldn't be. The recognition of this as a public good, a public service that we want to promote so that we can accrue the benefits of that public service. And as a result, we want to shift the burden a little bit away from the person providing that service. And so do these things really work? Do gross negligence standards really promote prescribed burning, since that is their intended outcome? So we did a study. We looked across the borders in areas that had gross negligence versus simple negligence standards, and looked before and after the negligence standard came into place so that we could assess some of these differences in prescribed burning. We looked right along the borders there in those green counties that you see highlighted. And the reason for doing that is just to control for all of the other complex landscape of things that come into play in determining whether one will adopt a prescribed burning practice or not. And so you can imagine that there are different weathers or topographies if you look at a whole state and compare that to a whole state next door. So we limited it to these little cross-county comparisons to keep control over all of those exigent factors, and then also added a lot of factors in that were other things that we could control for, like that might differ across those geographic boundaries. And what we found was we really were seeing landowners in counties with gross negligence burning more land. They conducted more burns and burned more acreage overall when they were in counties with simple negligence than their neighbors right across the state border in counties with gross negligence. Or, excuse me, I said that backwards. They burned more with gross negligence than simple negligence. And 2% that you see in that previous graph might not seem like a lot, but if you look at the Alabama study area, just these green counties includes 7 million acres. And if we switched from simple to gross negligence in just these counties on the border of Alabama and Georgia, that would turn to 150,000 more acres burned per year. So that 2% can be actually fairly substantial when we're thinking about gains in prescribed burning. And so what else comes into these right to burn acts? So placing the burden of proof on the plaintiff, that's one that people don't think about a lot, but in cases of prescribed burn escapes where you don't have a liability standard or right to burn act in place, there can be instances where the burden of proof will be on the burner to prove that they were not negligence. And that's a much higher burden of proof to go into when you're coming into a court case. And so this was a case from Georgia where, again, we had that kind of the smoke issue and accidents from smoke. 2 cars ran into each other in the street, and the semi which ran into the other car was trying to say that the burner was in fact the person who should be held liable for this. But the injured party did not present evidence that showed this gross negligence. And so it wasn't up to Carter, who was the defendant in this case, to show that he wasn't practicing gross negligence. But in fact, it was up to the plaintiff in the party to show that the burner had failed to exercise this slight care. And so this was a jury finding against Carter, and then a court coming back on appeal and saying there was no evidence presented from which a jury could have concluded that. And so they overturned the finding. And we did a study. We were kind of curious if this is going to be applied ubiquitously. So you do see courts applying gross negligence in Florida and Georgia and places where they've had a lot of time to have that precedent come into place. But there's other states who would think about switching to gross negligence. Are we really going to see a difference in how judges are applying this? And so we did surveys. We did surveys of district court judges who would be the court of first instance, who would hear these cases before they went up for appeal if they were in district court, and basically ask them which of these suite of things would alone constitute evidence of simple negligence. And then in the tan bars there, what about gross negligence? We split it up. We did the study in Oklahoma and Texas, and we split it up by state just to get an idea of if states where state court judges were acting differently. And we actually saw that for simple negligence average across both states, there were 7 of those hypothetical things that would constitute alone evidence of simple negligence, but overall only 4.5 of them would constitute evidence of gross negligence. And then we saw that to be a little more, the discrepancy to be a little larger in Texas than Oklahoma. And so that leads us to the opinion that perhaps both of these states would in fact try gross negligence cases differently than simple negligence cases, with fewer factors that are obvious evidence of gross negligence versus simple negligence. And we might see more of this in different states. So it might be a stronger push in Texas versus Oklahoma. And some of the reasons for that we could hypothesize about, but I think that it might come down to a stronger burn culture in Oklahoma, where you have judges that are more aware of prescribed burning. And so they're already applying assuming fewer of those pieces of evidence are simple negligence just because of that strong burn connection. So there are some other tools for limiting liability besides the liability standard in the Right to Burn Act. And it's important because it's very hard to get a gross negligence standard in a Right to Burn Act. And so some ways that places are doing this is with catastrophe funds. This is something new that California just started. I believe Washington is getting ready to roll one out as well, Washington State, where they're trying to balance this public good with private loss from the rare escapes that you have. And they used a lot of, in developing this idea of a catastrophe fund, they use a lot of the safety data that people had gathered in the state over time to say, we're doing a lot of these burns and not very many are getting out. And so where do these funds come from? Basically what it is it's in the legislation. It says there's a little fund here in the state. They can be funded myriad ways. If it is fire escapes and someone is suing the burner, we'll help the burner out and cover the settlement for whatever damages they caused. And it can be based on taxes, which I believe is how California has started theirs. They're hoping to shift eventually to another way of funding these. But for their pilot study, I think there was a smaller base of money and they used taxes for these. You could use new home construction in the WUI tax. That was something that was proposed. So when people are burning in designated wildland areas, their home tax will go toward these catastrophe funds. There can be reinsurance companies, private investment-based sponsors, lots of different ways to think about that. And then fees from certification is how California would like to go eventually, but they need to up their certification program and get more people on board with certification before they have sufficient funds in fees from certification to cover these catastrophe funds. And then private insurance is another way people limit liability all the time. We'll be having a workshop in Madison, the Northeast and Midwest Prescribed Fire Conference, and I'll be talking in a general panel about liability, and there'll be some more insurance savvy folks in there. It's not my area and I don't know a lot about it. I know there are some unique ways that people are thinking about insuring prescribed fire. There are some unique challenges as well. So that's a workshop where you might be able to get some more information if you're interested on thinking about insurance. And then liability limits is another way people have done this. Nebraska recently tried to put forth the Right to Burn Act. It didn't make it out of the committee, unfortunately, but they wanted to impose a liability limit on how much one would be liable for an escape or in case of an escape fire. And that's really important because everyone recognizes that these escapes are pretty rare, that prescribed burning is generally fairly safe. Escape rates are below 1% in most states. And the issue is that if escape happens, although there's a low likelihood, there's a high consequence. So a liability limit will lower that consequence. Look at another component of risk. And establishing CPBM programs, the Certified Prescribed Burn Manager programs, is pretty key in these. Most states do have this. Who establishes them is usually what gets set up in the legislation, that they must be there, and a state entity will be required to do that and set them up. What they look like varies wildly from state to state. One thing that is unique about them is that because of these Certified Prescribed Burn Manager programs and creating a state entity to provide these approaches, this is a really unique way to do law, where traditional administrative laws is performance-based. So it requires you to avoid certain outcomes. And so the criminal sanctions against burning would be this type of traditional administrative law, where you say if a escape fire happens, it's a misdemeanor. That's a traditional administrative law. Whereas these prescribed fire regulations, they're more management based, because the organizations that are actually conducting the prescribed burning and know the most about it, they're able to engage in the planning on what this law looks like. And this comes into play substantially in this process for creating Certified Prescribed Burn Manager programs. So this is an old map from Forest Stewards Guild. They're in Forest Steward Guilds in Washington State. Great document, a report that they put out, and I'm happy to share the link for that in the chat after my talk. But this is a little dated. It's 2020, I believe. And so I believe, correct me if I'm wrong, Minnesota, you all have a Certified Prescribed Burn Manager program. Maybe it's not fully funded, but it's set to roll out. I know Missouri rolled theirs out now, and I believe New Mexico as well. And there was one other state, Arizona, I think, was developing one. So it's a little dated. There's more.
Carissa, we actually don't. There's lots of conversation happening, but
Okay.
we don't have one of those certified prescribed burn manager programs here in Minnesota yet.
Okay. Thank you. That's helpful. I did, for some reason, I thought you did. Maybe it was Wisconsin that told me that they had one. Someone recently at a conference told me that they had one, and the map was wrong. And so these things they're proliferating around the country. There's a lot of them in development. There's a lot of them that are currently active. There are a few that are not implemented. That usually just means they haven't secured funding for them yet. But they're becoming really common. And they look all sorts of different ways. And so the variability among them is as much as there are states that have them. So you can see, for instance, Colorado requires, so they have two different levels of complexity. Burner B is a more complex landscape burn. Burner A is pile burns, I believe. And they require pretty much something that looks like an RxB1 from NWCG, which is opening task books, getting on wildfires. It's very onerous. It's very difficult to be a burner B in Colorado. Whereas Georgia for experienced burners, the track, they have just 16 hours of coursework, and prior burning experience can sub in for the coursework. So if you are a RxB1 or 2, you don't have to do this in Georgia. There is a written exam, but there's really not a whole lot else that's required. So, and then there's all sorts of variations on this. This column called alternative certification just means, will someone accept something other than your state certification course? Most places will accept NWCG certs, which the RxB 1 and 2 are prescribed burn BOSS 1 and 2. They are very onerous. So there aren't a lot of people who would choose to do that instead of a state certification course. And then when it says CPBM, that means if you're certified prescribed burn manager from another state, they'll accept that as well. So the rigor of the programs really have been shown to affect enrollment. They've been collecting data on some of these newer programs as they've rolled out. And so that one, the really rigorous NWCG level standard in Colorado, it's been active since 2014, and they only have 20 burner Bs. This slide is a few years old. They haven't collected updated data for the past couple of years, but this comes out in a report semi-frequently that I can share the link with as well. And then they only have 5 burner As. And so the burner Bs are those, pile burners, and burner As are your more complex burners. So they really haven't had very much uptake. Now they have a gross negligence standard that requires you to be a CPBM to take advantage of. So essentially they have no gross negligence standard because only 25 people in the state can take advantage of it. Whereas Florida has 5,000 burners who have been certified since the start of their program. And currently those are the numbers. They're pretty high. So it's not very onerous, and similar numbers in Georgia and other places that have a more watered down version. And it's usually just a course, some prescribed burn experience, and written exams, those types of things. So there's 2 different goals that people are looking for with these. And the reason that Colorado did what they did is not because they don't realize that they're not going to have a great amount of uptake, but they have really low public support for prescribed burning in Colorado. And they wanted to really enhance that by making it clear that they were being safe, that they were getting people certified. They had this whole program for it. I think eventually they're hoping to knock back how rigorous the program will be, but they want to increase that public trust. Whereas Florida and Georgia just really wanted to promote prescribed burning. So get as many landowners as you can certified so that they can take advantage of the gross negligence liability. So we have more safe burning in the state. And you can see that come out in the differences in the CPBM programs. And I mentioned this incentivization of certification. It's very clear in the realm of gross negligence. So the liability protection only accrues to those who are certified in most states. I believe Georgia's liability accrues to the burner regardless of whether they're certified or not. But every other state that has gross negligence, you need to be certified to take advantage of that limited liability. And this can be broken up. You can have limited liability for fire. You can have limited liability for smoke. So we saw in South Carolina where they were just smoke, now they're fire. And then California has taken the unique route of not doing gross negligence for fire or smoke because they were struggling to get that through their legislation, but they have adopted gross negligence standard for suppression costs. So if CAL FIRE gets called out to your burn because it's escaped, you won't have to pay for those suppression costs unless you rise to the level of gross negligence. There's also exemptions to burn bans, which has been one that's been seen to be pretty key, where certified prescribed burn managers in some states can burn just regardless of whether a burn ban is in place. Usually a state of emergency governor declared burn ban will override that, but if it's just a local county commissioner who's putting in a burn ban, then they can be exempt from that. In some states, Texas has that on the books. There can be extended hours for burning. Some states limit the window for burning, and a certified prescribed burn manager can burn beyond those hours. And then the same with seasonal burn windows. So if you shut down burning during a certain season for various reasons, certified prescribed burn managers can be exempt from those burn bans. And almost all places that have a CPBM program provide an easier filing for permits for certified people than for those who aren't certified, which is taking advantage of an electronic filing system or something like that. Just to kind of show a quick example of how these burn ban issues play out, we looked at a survey of county commissioners who were those who were placing burn bans in Texas and Oklahoma as part of that county judge study, just to determine the factors that influence how they decide to enact burn bans, because we were seeing kind of all over the place, whether it was based on specific criteria or whether it wasn't. And then also whether their level of comfort with prescribed fire plays a role in how they're deciding to do this. And we also wanted to look at that gross negligence liability shift, because that's something Texas talked about and didn't get to. Oklahoma's never really talked about it. I think they feel pretty comfortable with their prescribed burning laws. And then if that would impact their decision to implement burn bans, or if they would feel more pressure from people to implement burn bans. And so you can see that they're really kind of following, for the most part, a well-established criteria where they're looking at a high fire danger index. But we do see commissioners that say, can be at my discretion. 32% of our commissioners said they can put on a burn ban regardless of the fire danger index. And the ones that we saw who identified as very familiar with fire were the ones who were most often selecting a specific criteria, like the high fire danger index, and that makes pretty good sense. We also looked at if this shift in negligence from simple to gross would change the amount of pressure they would feel to enact burn bans. And we saw that for most people, it wouldn't. Pretty low percentage of the commissioners said that it would change how they were doing things. And oddly enough, it was kind of flipped as to whether they would, in Oklahoma and Texas, as to whether they would feel more or less pressure. And the same thing with the gross negligence, change the frequency with which you enact burn bans. Again, about half of them who said, of those, most of them said no, it wouldn't change it. Of those who did, about half of them said they would enact more, half of them said they would enact less. So there's something going on here that needs to be sorted clearly. But most commissioners are using objective metrics. That's good to know. Familiarity with fire is really associated with this. And so we talk a lot to people when we talk about promoting prescribed burning, about reaching out to these officials that do fire, your judges, your commissioners, the people who are in charge of limiting your possibility for burning, and just talking with them, getting them out on fires. We created a prescribed burn communication kit at the behest of a landowner in Texas. And it's a pretty good product. It's got a lot of information on who do you talk to, where do you find those people, how do you talk to them, how do you get in touch with them, and then more, how do you communicate with them, and then what are the tips for engaging with anyone who's important in the prescribed fire realm, from your neighbors to the media to these prescribed burn folks. And that's available through the Great Plains Fire Science Exchange if you're interested in that. And then the last little bit here is the regulatory requirements that are attendant to some of these prescribed burn acts. And so this example is from Florida. So certified prescribed burn manager must be present on site with a copy of the prescription, directly supervise the burn. You need that written prescription, consent of the landowner if you're not the landowner, authorization from Florida Forest Service. And then they have this additional regulation that requires adequate fire breaks at the burn site and sufficient personnel and firefighting equipment. That one's come up against a little bit of criticism for being a little vague. And so you can imagine if you go to court there, that leaves an opening. Despite the gross negligence standard, which protects people pretty well in Florida, they see this as a potential opening for courts to interpret this one way or another. What's an adequate fire break? Bring in experts, and two different experts will tell you two different things. So that's just something to consider in thinking about these right to burn acts, is what other regulations will be required and what do those look like when they're drafted? How well can they be assessed as to if you've done this or not? So quickly, I want to go over the policy process because it can be quite a burden, and then get to the Minnesota statutes with time enough to chat. So the policy process is pretty lengthy. The bill is usually drafted by prescribed burners, either a fire council these days, more often it's a fire council or a fire coalition of the state, or an industry group. The original one in Florida was largely driven by timber interests. And so the Forestry Commission and the timber industry in Florida drafted this bill. You need to find a senator or House member to support it. And it generally goes through a committee first. Nebraska's been having struggles in getting theirs out of the committee. The head of the committee is also the head of the Trial Lawyers Association, the head of the Ag Committee. And so it just gets floored at the Ag Committee level every time and never even makes it to the floor of the House or the Senate. If it does make it out of the committee and it gets put before the two pieces of legislature, it gets discussed and voted on. It has to be passed by both the House and the Senate, and then enacted without any vetoing by the governor. And so there's many steps in the process where things can get held up. One of the things that really does help with this is having this understanding that there's a big group in the state that is in support of this and galvanized to move on this. Helps to have industry support. I know Nebraska wasn't even going to attempt it without the Cattlemen's Association, but these prescribed fire councils are really key in helping to kind of organize everything, get everything moving, get the voices to the table. And as I pointed out earlier, there are lots of states have them now, and they're becoming more and more popular. The Coalition of Prescribed Fire Councils, it has developed as a way to help states develop prescribed fire councils themselves, and also to look at some of the overarching issues that cross boundaries that fire councils at the state level are facing that can be better addressed at a national level. And so this is a good resource for people looking to think about how to deal with some of these broader issues, and then also how to develop a prescribed fire council. So these are all the different prescribed fire councils. Again, I believe this is 2022. So Montana currently is thinking about starting one. They're in the process. They created a position to help galvanize, and California is kind of split into two, where they have a council in the top part of their state, but the bottom part doesn't have one yet. And then there's a few other places where they're developing listing green there. And so you can see quite a few places have these prescribed fire councils, and they're the ones that would lead the push for changing liability or legislation. And then thinking about these big national policy issues, so some of the things that the National Coalition helps out with are issues like this EPA plan for cleaner air. So they're trying to change the particulate matter standard. And that's really important because that trickles down to the states, and it could cut off a lot of prescribed burning if states are held to a higher standard for compliance under the Clean Air Act. Then they could potentially be tasked with shutting down more areas as out of containment, and that would be putting essentially a burn ban in place, because they wouldn't be able to conduct prescribed fire if they're close to attainment levels. And so the National Coalition has been drafting letters, working with councils to draft letters, working with EPA to the extent possible, working with the Wildland Fire Leadership Council to work with EPA to the extent possible. And so this is just an example of some of these policy issues that the coalition can help out with if you're facing some of these in your state. And then there's these ideas of regional cooperation has been coming up a lot for the Northeast and Midwest region. There's a bunch of different ways to do it. I'm not going to go over them now because I want to talk a little bit about Minnesota law, but there's just different ways where you can have the states in agreement on what your right to burn act will look like, and especially what certification will look like. So that applies across your region. So there's different ways that states can create more cooperation without having to go through the national coalition. And these are those compacts. I've just give a few examples over here. Multi-state privileges for EMS personnel became really important during COVID because we had a lot of people who needed to travel around and go practice nursing in other states. Before, there was no transference of your certification to practice across states, and then they created these multi-state compacts so that people could travel around better. Similar types of regional coordination work in areas where coastline is shared, and states will work together to manage coastline as broader groups. So just some ways you can think about getting together with surrounding states to have more cohesive right to burn acts. And this just quickly talks about these two different types of model acts, uniform laws. These are created from above and then adopted by states, and that can be a way to have conformity and across states to some extent too. And so Minnesota's laws that I can tell from my searching recently, this statute, the 2022 statute section 88, the Wildfire Act, is what really comes into play. And there's a lot of chunks of this, but this is the one that's relevant to prescribed burning and how it gets governed. And so basically the state of Minnesota is under a burn ban that must be lifted by the commissioner in order for someone to burn. Nebraska is very similar. That's why they're pushing for a right to burn act, because they have a constant burn ban and you have to require or request to do a burn from a fire chief or a volunteer fire department. And it's difficult to work under that type of a law sometimes, and Nebraska have seen this just because that it's very up to the idiosyncratic county to county. So there are some counties in Nebraska where the fire chief will always grant a burn permit to a prescribed burner. There's some places where they almost never will, and it's really up to the whim of the fire chief. The Minnesota statute takes it a little bit out of that realm in having the commissioner or the commissioner's agent be the one who's permitting the prescribed burning. And in subsequent agency documents, it seems pretty clear that the commissioner's agent is the one who's doing it, and the commissioner's agent is the Department of Natural Resource Conservation. And so there might be a little more cohesive across state because it's an entity that's statewide that's actually are permitting the burns. So you need these written burn permits, and they need to be approved by the Minnesota DNR. This careless and negligent fires section shows that you don't have that right to burn because they still have negligent fire start as a misdemeanor. And so if you start a fire, it gets out, and they've determined that is as the result of simple negligence, then you could be guilty of a misdemeanor in addition to civil fines. And so that's one thing that would be taken away by a right to burn act, is that nuisance or criminal component of it. And I'm gonna stop sharing my screen just so I can see if there's any insight that I don't have on Minnesota laws. It seems to be the one that's on the books. There are some smaller municipal laws that look like they come into play on a case-by-case basis, and depending on where you are, and then air quality standards as well that might come into play. The nice thing about having Minnesota DNR be as a part of this is that you know that you have a group that is overseeing this at the state level. It looks like there's been a report out that suggests that they will be in charge of certification. There may be complexity levels in the certification, similar to what we saw with Colorado pile burns versus landscape burns. And those complexity levels are pretty common. It's something that the NWCG uses and TNC follows, and a lot of other places follow, where a more complex burn requires a higher level of certification than a less complex burn. It looks like there's talk of ways to decertify once you're certified based on the action of the burner, but that generally it looks like certification, the discussions or the report seems to suggest that certification will be for up to 5 years. And it also looks like there's talk about establishing a prescribed fire council and making sure that's up and running. And so I'm not sure exactly the date on the report that had this all in place, but it looks like you did have the prescribed fire council established. It sounds like you did not have the certified prescribed burn manager program established. And so maybe that fell by the wayside. I know this report was not recent. It was from maybe 2018 or so.
I think it was 2016.
2016.
Carissa, thank you so much. This is great. There's been a really good discussion going on. You're probably not going to try to read it now as we talk, but Mark Herwig posted a couple of questions, and Lane Johnson responded with several. And so I'll draw other folks. Of course, I can share it with you later, Carissa, if you're interested. Sure. Of course, you can read it now if you want.
Absolutely.
But there is a fair bit there. The one question that I don't think has been addressed was simply in response to what you said about Florida. You said over 5,000 certified burners have been certified there, and someone posted there's a lot of burning in Florida, it seems. Is that on grazing land? Is it quail management or something else? Do you know what it is that's driving that high level of burn activity in Florida?
Yes. So it's largely timber, and that's site prep. Site prep is huge. They have a mesification problem where if you don't do active burning in your timberlands and your forest lands, they end up encroached by mesic species, and then you can't get fire through there. And those and what would happen in an area where you haven't done site prep with fire and you take trees out is you create these canopy gaps, and those mesics blow up, and you would just end up with woody plant encroachment in your understory. And it's costly and time consuming to treat with herbicide or mechanical removal. And so really, it's really driven by both big timber industry and small timber interests. But there's a lot less grazing in Florida than there used to be. But there are some grazing lands, and then a lot of the public lands are doing similar kind of reclamation burns to reduce mesics in order to open up areas for quail and pheasants and other wildlife. So it's a mix, but largely it's controlling those woody invasives and other invasive species.
Yeah. Great. I would invite folks to submit additional questions. Again, I think that's the only one that we've got so far that has not been addressed. There was another question that I'll just briefly review. I won't read it all word for word, but Mark also asked, is there any idea how many acres burned in Minnesota before European settlement? And Lane mentioned a fire needs assessment that suggested that of the natural lands still intact today, so not converted to ag lands or urban and so on, about 1.2 million acres would have burned annually on average. And Lane goes on to talk about, we'd be lucky if we could achieve 10% of that acreage per year across all lands. And again, folks can read further. There's a reference also to that fire assessment report and the data underlying it. So if folks are interested in that, they can see the link in the chat. Thanks.
That fire needs assessment is pretty key for a lot of places in moving forward with this kind of stuff, and has been essential, and they will be updated periodically. It's a lot of work, but and how much is being done. I guess that report comes out annually, and the National Coalition of Prescribed Fire Council's website has a link to the acres burned report.
Yeah, great. Thanks, Mark, for the questions, and Lane for sharing that information. That's great. Question just posted, given that Minnesota doesn't have a right to burn language, does the burden of proof lie with the burner in the event of an escape?
Not always. It can be up to court interpretation. So that's where that having it is helpful sometimes in that regard, but not, oh, it's not going to apply everywhere. The level of utility of the shifting of burden of proof. Courts that are following traditional law tend to place the burden of proof with the plaintiff, but it's not always the case. It just depends on what the precedent in that court is for tort law. And
Carissa, I wonder if you can say a little bit more about that. You defined strict liability earlier in the talk as, what I wrote down was, if oh, I guess I didn't write it down. I think I remember you saying, like, if something goes wrong, you're liable regardless of your actions.
yes,
That would suggest that burden of proof is maybe doesn't even really come into play. Like, if something happens that's out of your control, well, if you were the one that started the fire, you could be liable. Can you say more about that? Is that truly?
absolutely.
That seems
Yeah,
like
that so that were states that actually have strict liability as defined as a standard, and there, I think Hawaii is one. That is absolutely the case. Yeah, where it doesn't matter what the action is. That is, they class them as ultra hazardous activities, and so things like blasting to create tunnels or bridges, if